I now call on Richard Baker to speak to and move Amendment 4987.2. Mr Baker.
Thank you, Deputy Presiding Officer. In February 2007, Cathy Jameson wrote in the foreword to Modern Law for a Modern Scotland of the need for reform in our civil justice system and to have laws which provide accessible ways to sort out problems and protect rights. She announced then that Lord Gill would lead the review, whose conclusions we have a welcome opportunity to discuss today. And it's important that Parliament recognises the great contribution which has been made by Lord Gill and his colleagues in producing this report. This has been the work of over 2 years, and it does not disappoint in coming forward with bold proposals. They do need to be debated and they do need to be tested. But the report makes clear that while we are rightly proud of our justice system, there is a need for reform. We have tabled an addendum to the Scottish Government motion stressing the importance of two fundamental principles which inform our approach to these issues: access to justice and efficiency in our justice system. The key perspective must be that of the person who seeks access to the justice system. Justice for them must be dispensed fairly and, yes, speedily, and they should not be excluded from the justice system because of lack of means or any other barriers they face. They have a right to have their case heard in the most appropriate setting and by a court with the appropriate expertise. There is clearly benefit in having a number of sheriffs designated as specialists in particular areas of practice. This was a case made by family practitioners. And in cases such as these, there are clear advantages from having sheriffs who specialise in family law, both in terms of continuity and consistency in decision-making. The argument is also well made in terms of cases becoming protracted because of the pressure of other court business, particularly, of course, criminal business. When cases involving adoptions or referrals from children's hearings are affected, this is clearly undesirable, as these cases are sensitive and emotive, particularly for the child involved. So a compelling case has been put for sheriffs specialising in one or more areas and for the creation of the new judicial office of district judge to hear summary criminal business and civil claims of a modest value. It is to be hoped this will make court procedures more efficient. Too often we do hear from constituents whose cases, for often relatively small claims, have taken far too long for them to resolve, in some instances so long they have not been able to continue them. That is clearly not fair or just, and so I welcome the emphasis in the report not only on sheriffs taking a greater role in managing cases, but also in cases where it is appropriate the use of lay representation, as David Whitton referred to in his intervention. This is of clear benefit to those who otherwise could not afford to be represented.
Margaret MacDonald.
It may have been a slip of the tongue, Deputy Presiding Officer, but in fact Mackenzie's friends are not representatives, lay representatives in court. They are lay supporters for someone who is litigating on their own account.
Mr Baker.
A slip of the tongue, and I'm very grateful to Margaret MacDonald for the correction on that point. Another positive in the report in terms of enabling people to have better support in their engagement with the justice system is the proposal that the Scottish Government should develop and extend in-court advice services as part of improved provision of publicly funded civil legal assistance and advice. Clearly, this will also require appropriate resource, and even in these straitened times for public finances, that can't be escaped. We can't hope to reap the rewards of changing the structures if, for example, there's an agenda to close many sheriff courts. The issue of the costs of the system are, of course, referred to in this report, and the STUC, the Trade Union Unite and others have highlighted their fears about the effect of steep rises in court fees, and they are right to do so because of the potential impact on access to justice. And it's of course right that the review should look to reform in the Court of Session and how to ensure it can best play its crucial role in the delivery of civil justice in Scotland. The proposals here will undoubtedly be the subject of future debate because of the proposal that the Court of Session should deal with cases above a value of £150,000, with other cases going to sheriff courts and a new specialist personal injury court with an all-Scotland jurisdiction. A new specialist personal injury court also raises important questions of resource, including ensuring the allocation of an adequate number of sheriffs to any new court. And I'm also aware that the STUC, Unite, campaigners on asbestos-related disease and personal injury practitioners have serious concerns about how these proposals will affect them, as their cases are currently heard in the Court of Session. We should ask the question not only if the £150,000 limit is appropriate, but also of whether the monetary value of a case alone should determine in which court it is heard. I am aware that the report refers to the potential for the judge at case management hearings to consider whether a case may have special features which would justify its retention in the Court of Session, and this points to the potential for cases of relatively minor monetary value, nevertheless being complex in points of law and potentially important in creating case law, not just for Scotland, but for the UK. And so it's not only on the basis of monetary value that cases should be considered as being appropriate for the Court of Session. And the wider resource implications of these changes will have to be properly considered, particularly as the report makes clear that the recommendations should not be cherry-picked. It should not simply be a case of the most affordable proposals being implemented first, and Robert Brown made this point to the Cabinet Secretary. Presiding Officer, it is impossible in the time we have this afternoon to cover all the crucial issues raised in this extensive review. What is clear is that this review should be fully and carefully considered with wide consultation, as Bill Aitken's amendment refers to, and I welcome the Cabinet Secretary indicating there will be public consultation. The motion also refers to the forthcoming report by Professor Walker. The Calman Commission has highlighted the potential for Scottish criminal justice cases to be taken to the UK Supreme Court, where convention rights are involved, and this issue should indeed be resolved, as the judiciary in the Court of Session stated in their evidence to the Commission. But I hope this will be achieved without considerable upheaval. So we will return to this matter and, of course, to the Scottish Civil Courts review as well. And this report, of such importance to the future of our justice system, must receive full parliamentary scrutiny. This is a major and substantial report, and I welcome the opportunity to discuss these matters with the Cabinet Secretary, and I will certainly take up his invitation to do so. But I do believe it is too an important issue to be conducted with undue haste. The priority must be for legislation to be brought forward and debated, rather than piecemeal implementation. We are indebted to Lord Gill and his colleagues for their excellent work in bringing forward substantial proposals for major reform to modernise our civil justice system. It is our duty in this Parliament to give this report the full debate and consideration it deserves. Today is a welcome beginning to this vital work as we look to reforms in civil justice founded on ensuring that cherished right of recourse to a justice system in Scotland of which we can be proud, and I move the amendment in my name.
I now call Bill Aitken to speak to and move Amendment 4987.1. Mr Aitken.
For many people, including many of those who are actually involved in the law, the civil justice systems in Scotland are clearly operating in a time warp. And I think there is a unanimity throughout the Chamber